I'd like to introduce the team here first. Not everyone's here, but most of us are. You can see Karen Christie, you can see Kevin Chin, you can see Monica Kimmel, you can see Diane Verano, and you can see Victoria Spray. Jennifer Clark isn't here this evening. She'll be taking part in the lunch hour event tomorrow. We'll be happy to answer questions as best we can. There's a lot of material to present. You'll find that after about 60 minutes that it's been a lot to absorb. We'll continue on talking, and gradually we'll answer questions for about 15 minutes after 8 o'clock. And people will slowly go off and go to their beds at some point. But we're very happy to meet everyone today. I see there's already 7 questions. I think, Karen, your best ever was 150 answers in 75 minutes, which is pretty good, I think.
Yeah.
For the people that contact us, the first intake point is Kevin. He's the one that sets up either a very short chat to speak to the assessment we've done from the family details, or he sets up the proper consults that are paid consults. And then once we've had a consult, we can see just what needs to be done and discuss the fees involved and go on from there. We often also find that people don't proceed with some of the things until years later, and that's largely because they're busy. They have circumstances that keep them from it. But as time allows, we'll be happy to help. So I'm going to start. I'll speak first. Diane will speak about 6 slides a little later about guardianships and powers of attorney. So the great thing about this first slide is that I'm never going to change it, and I'm never going to get any older than that.
Ken, before you start, I accidentally put the first question on the list that you would like to answer this question live. And in fact, I was meant to answer it. So I don't know how to get that person to resend me the question.
Okay, well, you just told them to resend it.
Okay, well, they know.
Do I understand correctly that you something happened to it and?
Yeah, I said that I'll answer it live, but in fact, I was going to answer it typing.
I see. Okay. So whoever that was, please send it again. So here's the numbers. This just gives you an idea that you're not really crazy and alone. 1 family in 10, if you do the stats, is a parent household of someone with special needs. Who knew, right? And you can see here, if you quickly look through this, I'll try to be brief, but to explain things that need explanation. Everyone that has registered will receive this recording and the PowerPoint slides. So you can see that if the population is 13.7 million, which is essentially still correct, what StatsCan says is that you divide the total by 3, and this gives you the number of households. And if you look at the number of people who were on ODSP as of February 2020, and I've been trying for, the last 6 or 7 months to get updated stats from ODSP, they're generally quite forthcoming, but for some reason they haven't forwarded more current information. But you can see that in 2020, and the number will be slightly higher now, that there were 378,000 people on ODSP between the age of 18 and 65. And about another third is made up of people who are under 18 or over 65. So of course, if you're under 18, you're not on ODSP, and if you're over, you're 65, then you're a senior citizen, and you're on OAS and gains and whatever other supplements there may be. So you could gross that number up to, let's just say, 478,000. So what this means is that if you had 478,000 people on ODSP, that's about 10% of the number of households. And so this is where the simplistic number comes from for 1 in 10 households. You can see also that would be of interest is this border number, 48,000. That's about 14%. That's the number of people that are still living with parents or with family. If the parents are deceased, they might be living with a brother or a sister. These are all the people that are living with family. It's only about 14%, as you can see from the numbers. These are the people who have all been slotted into room and board rather than shelter plus supplementary. So when we get to the slide further on, you'll see that these are the people, these are the 48,000 individuals who are living with family, where we're going to seek a benefit increase for them. This is a breakdown. It's not as exact as you might like, but for example, there's nothing there for autism, but it does give you some sense of the numbers or the percentages of different types of disabilities. And you can see that if you were to look at this from the context of legal guardianship, for example, or power of attorney, you can see that there's a large number with developmental disabilities and with psychoses and neuroses who might very well not be competent to manage money or personal care. So it's a substantial number, as you can see. So let's just say 60%. So you can see that a large number of people on ODSP may well not be able to manage their own affairs to the extent that they are not competent and that legal guardianship may be required. Now, of course, we always try to make powers of attorney work if it's at all possible, because the process is obviously much less expensive. But you can see, this gives you some context for the numbers. And this is the breakdown of the different municipal areas. And you can see here, where's Ottawa? Here's Ottawa. So Ottawa has a population, they say, the sign on the road says we have a population of 1 million. So that would be 333,000 households. And you can see that there's 25,000 people on ODSP. In their households, there's a total of 34,000. So this will be some spouses, children. And this ACSD number, this is that's the acronym for Assistance for Children with Severe Disabilities. And it doesn't really turn on the severity. It turns on the low household income of the family, such as a single income household. So if the household income is less than approximately $45,000, that household, that person, that minor, could receive ACSD funding, and it's maximum, they've just changed it, it's just increased, but maximum of about $450 a month, which is paid by the same ministry as pays ODSP, but it's for minors. It's like ODSP for minors in households with modest income. So for example, if you were a person on ODSP in Ottawa and one of the beneficiaries of your benefit unit, as they're called, was somebody, your child, with a disability, you have a disability, the child has a disability, then you would qualify to get ACSD of the maximum amount, and the ACSD would not affect your ODSP. So if you know of any households like this, which I'm sure you do, where there's a parent on ODSP and there's also a child who has a disability, then the odds are very high that the parent is not receiving ACSD. So we should discuss that further. The amount of benefits has just recently increased at the end of September. For the room and board used to be $896, and the shelter plus supplementary was $1169. So it's just increased. And these are the amounts that you'll see on this next further slide that we try to get increased, because the 938 is the room and board amount. It applies to the 45,000 people that are living with family, typically. Typically, they're slotted into room and board at age 18, and it just never changes. It's possible, in a lot of cases, to get it increased by $290 a month to the $1228 by setting up documentation to convince ODSP that they can shop and cook and they can pay shelter costs to their family member, sort of in lieu of rent. And or generally successful. There has to be some credibility to the ability to shop and cook and to pay, quote, rent. This reference here to tax credits, another very common thing we do at the start of meeting a family is we determine if they're using or should be using the disability tax credit and the caregiver credit. And if they're not, which is a very common profile, we see that these credits are approved and put in place and then adjusted. And we can recapture going back up to 10 years. And the recapture is approximately $16,000 and $10,000 respectively. If it happens to be a minor, child under 18, then that 16,000 would more likely be 22,000. And as well, this would affect the Canada Disability Child Benefit, which is a supplement of approximately $2,500 a year to the normal child benefit. And that also can be recaptured retroactively. In order to receive ODSP, you have to qualify. And this definition of qualification isn't really how it's done, but in a simple process, this is the test. Of course, you have to either have a doctor complete a disability determination package, which is then sent to the disability adjudication unit, or you have to, if you have a child with cognitive impairments, you have to start working with Developmental Services Ontario, say 6 months or so before they turn 18. And if Developmental Services Ontario agrees and accepts that this is someone that they should be providing services to, then you can take that letter of approval and you don't have to get medical approval for ODSP. So you can see that's a saving grace for people who have kids with cognitive disabilities, developmental disabilities. The rules are similar to what they were last time. The occasional gifts of cash over 12 months is $10,000. The asset test was increased fairly recently. You'll recall that the asset test used to be $5,000, and the gift over 12-month rule used to be $6,000. So you could receive $6,000 from someone, but you could only have 5. So now it's $40,000, which is a bit more workable. And if you happen to have a spouse, there's an additional $10,000. How are the questions coming along? Karen, I see there's 8 on the list here. Are we getting a lot of questions?
Yeah, some of them you will be touching on it in the webinar. So I've just sort of said we'll be discussing it. We've answered 26. We have 10 going right now.
Okay, good work. Good work. Now, I think one of the biggest changes is just very recent. Apparently about 18,000 people are working and reporting income. There may well be people that are working under the table. I wouldn't doubt that at all. And I don't think that's necessarily a bad thing. Work is a good thing. Work is sociable. Work means money to some degree. Work means getting out. So used to be, until just recently, that the first $200 a month that you earned was exempt. And if you did earn 200, then ODSP would give you a further 100 from benefits. So that's okay. And then after the first 200, there was a 50% clawback. So now it's $1,000 exempt. And here's the calculation about how it's calculated and where it breaks even. So you can see that people earning $1,000 a month or less are much better off. People earning more are still better off for a length of time. And it finally comes even. The formulas come together at $2,500 a month, which is about twice ODSP, which is about the amount that disqualifies you financially. And I was just discussing this with Karen today. If you earn $1,000 on top of $1,228, and then you do the math, it works out to about $26,000 a year, which is about full-time employment, 35 hours a week at minimum wage. It's approximate numbers. So that means that you're getting $1,228. First 1,000 is exempt, so that's $2,028. And now you multiply that by 12 and so on. Math isn't complicated. And it's essentially like full-time employment while on ODSP at minimum wage. And then if you want to save the money, as the earlier slide says, you can have up to $40,000. Now we have ways of exempting a further $100,000, which I won't go into this evening. So if you're a parent household that has an adult child who is working and you want them to save money, perhaps to buy a car, well, obviously they can save up to $40,000. And if you wish to do something more than that, like setting up a TFSA and investing and so on, we can assist you with a further $100,000. Of course, that's all in excess of any amounts in an RDSP. This is something that's just starting to come on the horizon. Legislation for what's being called the Canada Disability Benefit, which would be a federal benefit, which of course we wouldn't want to affect provincial benefits, was proposed prior to the last election. But of course, when the election came through, there was a proroguing of Parliament, so the legislation fell off the table. It's been reinstated. It's got second reading. And if it should be given royal assent or passed by Parliament at least before the next election, then it would be law. It would be an active statute. Now, it wouldn't come into effect until the regulations, which of course would determine how much these benefits might be and under what circumstances who would receive it. Those are all left to be determined, right? But, we live in hope. Let's just see what happens. I think this legislation will be passed. What it'll wind up doing and when, that's just an open question. This is a matter of getting approved for the disability tax credit. So if you happen to have a child, I'm sorry, I underestimated how much I talked today, because I do a lot of talking. Just excuse me 1 second. It's nice to talk to people, but at the end of the day, it's a lot of talking. So we often find that a family child is 24 years old, for example, and because I'm just thinking of a file that we dealt with the consult today. The child is 24 and has never received ODSP. It would appear that she should. We're just collecting more information to make sure. And I'm just going to skip back to this earlier slide. Just a sec here. Here, this one: can't function in a competitive workplace or the community or handle personal care. That's a sort of a three-tier description of who might qualify. That's not how the disability determination package lists it. It has pages 5 and 12, which have activities of daily living, about 12 or 16 of each. And page 5 deals with cognitive and mental health issues. And page 12 deals with physical. So in this case, it wouldn't be physical, it would be mental, cognitive, mental health. And we often find that we need to do an ODSP application, which turns on having enough number 3s in the column, which is a scale of 1 to 3. And we often do the disability tax credit application at the same time, although the test for the disability credit is quite a bit higher. You have to be markedly restricted all or substantially all of the time You have to need constant supervision. You have to be unable to set and keep goals. You have to take markedly longer to do things than other people. So it's quite a much higher test. But if you do get approved, then you can do that recapture that I mentioned, the $16,000. And as well, you can then have a registered disability savings plan, which we'll come to in a moment. These numbers here, I suppose I should update them. The tax returns for the last year or two now have 3 zeros after these main numbers. So I suppose I should have Christian add 3 zeros after this, or 2 zeros, sorry. But the numbers otherwise are the same. The caregiver credit is not the disability credit, it's the credit of the caregiver, which does not have to be approved the way the disability tax credit does. And it only comes into effect after the person has turned 18. So if they were 28, then we could potentially do a 10-year recapture. And what happened, a big change in 2017, which is now 5 years ago, was that prior to that, the person had to reside with you. Now that's not a factor. So what that means is that prior to this change, only the people who were at home with family, only those parents, those siblings could use the caregiver credit. But now in practice, I would say that virtually all of the parent households could use it. That's granted, there are some, excuse me, some people that are estranged, but that's not a big number. So what this means is, approximately 365,000 people instead of about 18,000 people can use this credit. So if you have a child that you're a caregiver of, then I'd like you to check these 2 lines on your tax return, because this, I think, is the most commonly unused credit. And then if you look back to age 18, that's the number of years that we could retroactively recapture it. And it's about 1,000 a year. Now this is starting to talk about registered disability savings plans. And if the person is approved for the disability tax credit, then they can have a registered disability savings plan, which is their property. And simply put, if the person is 18 or over, then based upon their household income, which is just ODSP, they'll qualify each year to get a $1,000 bond for just having the plan open for 20 years. And if someone contributes $1,500, there'll be a further $3,500 contributed by the federal government each year. This goes on for 20 years or until age 49. Here's a further explanation. And there's a 10-year vesting period. So if you contribute the $1,500 and get the $3,500 grant and also the bond, then if you can keep contributing for 20 years, you have to wait a further 10 years before all of the grants and bonds are vested. So you can't really withdraw anything for about 30 years. So if the person's 18, 30 years, 48, and what's held out is that the plan is to wait until the adult child is 60, and then to have the money dispersed. You can see here that at age 60, starting at age 18, at age 60, it's a 5% growth rate, that it would be approximately 700,000 at age 60, which would then, if you follow that LDAP formula, would pay about 30,000 a year for the next 23 years. This is good. This has never occurred before, that a person who has a disability so substantial that they qualify for the disability tax credit would have such an asset. And of course, what that does, as you'll see in a later slide, is it brings us back to the discussion of legal guardianship, because the parents are allowed to be the account holder. They're not the owners. It's not like an RESP. They can be the account holder for the child if they're not competent. The child is the beneficiary and the owner, but the parents are at present the only parties who can be account holders, other than a legal representative, which means either someone appointed by power of attorney or legal guardianship. This is just a simple explanation, a graphic explanation of that $700,000 calculation. You can see that you start in a given year, contribute $1,500, it earns interest, and there you are. I've had people ask me, well, my child has Rett syndrome, or my child has a shorter than expected lifespan. Should I at some point simply stop contributing and getting grants and bonds? Victoria, would you mind bringing me another glass of water? I should have had another. I had a glass, but it's all gone now. So you can see that people have never had this kind of money before when they may be completely incapable of managing it themselves. And as Diane will explain later, this then gets us into the question of legal guardianship applications. This is just a slide. You can look at it at your leisure. And these are some other speaking points about RDSPs, holdbacks and disbursements and payout procedures and so on. I see we're up to guardianship already. Oh, thank you. Diane, would you like to take over? I'll just mute myself and you can carry on. Now, you tell me when you want me to move the slides and I'll move them forward.
Sure. Hi, so good evening. My name is Diane and I'm one of the lawyers here at the Law Office of Kenpo. So this first slide is a brief list of the types of work we do with regards to substitute decision makers. So on that list, you have guardianship applications, we do that. Power of attorney documents, we do that. Substitute decision making matters, we do assist clients with those types of matters. And then trusteeship and trustees, we do assist with that as well. Ken, can you go to the next slide? Okay, so this first slide is called Power of Attorney for Personal Care. What I'm going to explain just briefly and simply is what is a power of attorney? So we get that question a lot. And in simple terms, a power of attorney is a legal document that you sign to give one person or more than one person the authority to manage your money and property on your behalf. And in Canada, this is what we call an attorney. So if we're looking at power of attorney for personal care, it involves, for example, and you'll see on the slide, decision-making ability over what health care you'll receive, maybe decisions over where you live, how you'll dress, what you'll eat. So matters that involve your personal care. And I'll just take a moment and let you look over the slide. This is just a brief summary of what a personal care power of attorney is. Okay, and as Ken mentioned, we will have these slides available for everyone who registered afterwards, so you can review them afterwards as well. If we can move on to the next slide, Ken. So this is just in a nutshell, a brief picture of what a power of attorney for property looks like. And it involves, for example, someone as their attorney who will pay your bills, access your accounts, manage your mortgage payments. So anything that deals with assets and property No, I'll just pause here and let you take some time to review that slide as well. Okay. And do you mind moving to the next slide? Substitute decision maker. So what is a substitute decision maker? Well, in our office, generally that means a guardian or power of attorney. Now, if you're someone who doesn't have any of those things, so you haven't appointed a power of attorney and no one has been appointed to be your guardian, well, there is something else called the Healthcare Consent Act in Ontario. And this specifically deals with a person who is incapable of making decisions regarding consenting or refusing medical treatment. Now, under the Healthcare Consent Act, there is a hierarchy of persons that that can make that type of decision-making power for you if you cannot consent. So the first would be an appointed representative from the Consent and Capacity Board for the person. Next in line would be a spouse or a partner of the person who can't consent. Next in line would be a parent or a child of that person. After that, it would be a parent of the person who has only right of access. After that would be a sibling of the person who can't consent. And then after that would be any other relative of the incapable person. I do get questions of, if we have this Healthcare Consent Act in Ontario for personal care decisions, are there situations where getting guardianship for personal care is still appropriate? And the answer is it depends. So the right way to go about it is to call our office and we'll go through the pros and cons and see if getting guardianship is appropriate for you in that case or not. Ken, can you go to the next slide? Okay, so this next slide is, again, just a snapshot about some of the main points of guardianship. There are two types of guardianship, like there are two types of power of attorney documents. So one for property and one for personal care. Guardianship appointments can be granted through the court. Those are the types of guardianship applications that we do through court. Or they can be granted through statute, and we call that statutory guardianship. And we do assist with some of those as well. One of the big questions that we get is, what is the difference between a power of attorney and a guardianship? And one of the big differences is the decision-making power ability of the person. So with a power of attorney, the person who has signed it and granted the appointment of their attorneys, that person is able to understand what they're signing, the type of power that they're giving away. They can understand their assets, they can understand their own personal care, and they still have the ability to make decisions regarding property and personal care, notwithstanding that they've granted power of attorney documents. With guardianship, there's usually, well, there is, when we do guardianship, they've been assessed and they've been found incapable of managing their property and managing their personal care. So in that respect, they aren't able to sign power of attorney documents. And the only option that they have, if it's appropriate, is to apply for guardianship so that someone can make those decisions, step in their shoes, and help them with their personal care and property matters. And if you can go to the next slide. This next slide just, it goes through some of the major questions that we get from clients. The first one being, what is the process like? In our office, we do guardianship through a process called summary disposition. and that is an application in writing. So there's not going to be any court in-person appearances. We draft and we submit what's called an application record. The public guardian and trustee reviews every single guardianship application. They write to us with their questions. We answer back with, again, in writing, if they have any questions. The judge, if they have any questions, they will also write to us, and then we answer if they have questions. And at the end of that process, if the judge is satisfied, they will sign what's called a guardianship judgment. And it's usually maybe four to 8 pages long. This process also involves medical evidence. So we do seek the assistance of capacity assessors. And what these capacity assessors will do is they will meet with the person who is allegedly incapable. And nowadays they can meet through virtual means. So for example, Zoom, and they will ask questions of this person and assess whether or not they're able to make decisions regarding their property and their personal care. So that is a major component of the guardianship process. I'll jump to the middle question here. What is the role of the public guardian and trustee? So we tell all our clients that the public guardian and trustee reviews all of the guardianship application information. They like to pay attention to what's called the management plan, and the management plan lists the assets of the person who is allegedly incapable, and they comb through it like a fine-tooth comb, and they just want to make sure that the application and the people who are applying have a good relationship with the allegedly incapable person, and that they've presented a good plan regarding the management of the funds and regarding the management of their health care. The next question below that is, can I apply with another person? And the answer is yes. And some people don't know that. One of the questions I get after that is, can I be the primary guardian and my brother can be the secondary guardian and my niece can be the third guardian? And the answer to that, unfortunately, right now is no. There is no hierarchy of guardianship. If there's more than one applicant, all three of you, if there's 3 of you, are jointly appointed together. So you all have the same powers at the same time. And there's other questions associated with that, but I'll leave that to when we talk on the phone in person. The next question is, how do I know whether a guardianship application is appropriate? And that's a very good question. Because of the nature of our business, when we do get phone calls or emails from people who are experiencing problems that affect their ability to make decisions on behalf of a loved one with disabilities, it's usually, if we're talking about property, maybe it's something like they can't access a bank account. They can't manage funds for the person who's allegedly incapable because their name is not on the account, for example, and the bank is giving them trouble and they say, I'm sorry, but this is an adult. Until you have guardianship or some substitute decision-making authority, we're not going to let you have access to this. Sometimes there could be financial abuse, and our clients want to protect their child from this sort of situation. Maybe their child is easily influenced. And as Ken said before, sometimes clients come to us because without guardianship, they can't make elections for a person that will enable tax deferrals. Maybe there's an inheritance that's coming in, a large sum of money. This person has never had this much money coming to them before. It's not something that they'd be able to handle, so maybe guardianship would be appropriate. We've also had clients come to us because they want to sell property. And for example, maybe it's a spouse that was on title that can no longer sign a consent to enable that property to be sold. And if we're talking about examples of personal care issues when clients come to us and they call us, it could be as simple as not being able to book an appointment, a medical appointment. Some of our clients' children are nonverbal. So this, as you can imagine, is very hard for someone who's nonverbal to book an appointment. So, you know, our client parents are frustrated. The person can't sign a power of attorney. Is guardianship for personal care appropriate in that situation? There's also maybe parents can't get access to medical records because their child is an adult now. Maybe they're, you know, this is important information that the parents would like so that they can better take care of the child who's been in the hospital maybe for a month, but no one is getting back to them because the child's an adult and there's privacy issues. So those are just some examples that I can think of off the top of my head where clients have come to us and we've had you know, a very fruitful and long discussion about what guardianship entails and whether it is appropriate, depending on the facts in their own situation.
Excellent. Thanks, Diane.
Thank you.
I'll just make a few comments. When we have our initial consultations and discussions, it's a balance a lot of times as to whether now is the time to seek guardianship, because of course the parent can be the ODSP trustee, they can be the account holder for the RDSP, they are technically the substitute decision maker for personal care. Sometimes there's an issue with respect to filing tax returns, but what I've heard people do is to go online and pretend they're the person, or to have the person simply make a mark on a representation agreement. And Canada Revenue is not very sticky about this because they're happy to have somebody file the tax returns. But what does happen as people get to what we call the awkward age, say 60s, is, you know, they're still young, they're going to be around for another 20, 30 years. But they do from time to time read the obituaries. They have a sense of the fact of mortality. And what happens is there needs to be, just as there's a financial succession plan to care for the child with a Henson trust, what about the child? Excuse me. What about the child themselves? Because of course the trust deals with the asset inherited from the parent. So what happens is you need, if you're fortunate enough to have several children, to have siblings for the child with special needs, which is not always the case, then you apply for guardianship along with one or more of the siblings. So when the parents are gone, these existing guardians are still in place, and they can then become the account holders for the RDSP. It's all set. They are legitimately able to file tax returns. They can do anything. They stand in the shoes of their brother or sister. For medical purposes, they have much more clout than a substitute decision maker. I mean, it's hard enough. Anyone who's dealt with medical situations, doctors and hospitals, know just how hard it is, even as the spouse of, or the son or the daughter of someone who has health issues, how difficult it is to get access to information, to be informed. Legal guardianship means, as I just said, that you stand in the shoes of that person, and you are the one to provide informed consent. And of course, if you provide a notarial copy of the certificate of appointment, I think what medical authorities, fairly quickly figure out is that you have a lawyer and that you understand informed consent, and that it's from those kinds of the slippage around informed consent that medical malpractice suits flow. So you have a bit more clout. There are a few situations, not many, where the assessments are done and the parent passes on, and the only person around, the only institution around, is the public guardian and trustee to take over and to help manage that person's finances. The PGT does not typically take over as the public guardian for personal care. It's usually just property. And as we'll see on the next slide here, there's an additional reason for the families who will have a pension for a teacher, a municipal employee, hydro, power generator, workman's compensation, WSIB, because as this slide shows, the adult dependent children of people with provincial statutory pensions, which is teachers, OMERS, OPG, WSIB, and also some private pensions, the children, the adult dependent children, stand to receive 50% of the original opening pension. It still passes to the spouse first, of course, but then it potentially passes 50%. So, for example, if it's a teacher could certainly retire with a $60,000 pension. So potentially, a few decades later, their child, who may, 14% live with their parent until they die, but otherwise the adult dependent child, who may be living, so, you might say independently, but they're not really living independently, they're living with supports. The adult dependent child could stand to receive 50% of that opening pension, so $30,000. Well, this of course would disqualify them from ODSP, but 30,000 is better than 15,000. And usually you can deal with the medical drug issues. And of course, if 50 to 60% of these individuals are not competent, then someone has to be their legal guardian to apply for the pension and then to receive it and to administer it. So it's a very interesting scenario that is especially pertinent for people like this, and also for anyone who has an RDSP, which by age 60 is going to be $70,000, and pay out that same $30,000 a year from the RDSP rather than from the pension. But it's a problem of similar scale. So those are some of the other reasons that we find that people are more interested. And from a demographic perspective, the peak of the baby boom turned 65 last year. And what this means is that one family in 10, which has a child with special needs, turned 65 last year. And so, of course, they're all at the awkward age where we should discuss legal guardianship. Now we finally come to Henson trusts. I think everyone here listening probably knows the term Henson trust, but one of the most common things we find on our family details form that I, again, suggest that you go to the top right and drop down and fill in is, do you have a will? Yes, no. Does it have a Henson trust? Yes, no, unsure. So, of course, if you don't have a will, you don't have a Henson trust, so that's easy. If you do have a will, you may know for sure that it's just, all to my spouse and then to the kids, and that's all it is. And then there's unsure. And the reason it's unsure isn't necessarily because there isn't some sort of trust provision, which of course we'd have to review to see if it's adequate, but it's because it hasn't been flagged. And the will was done, 10 years ago, 15 years ago, perhaps. And you think you can recall that there's something in it to provide for your daughter, but you don't quite know what. So you tick the unsure box, and we then have to see just what is going on. So of course we always put, Henson Trust in the wording in the will, and we always highlight and bold, just as we are here, some of the essential wording for a Henson Trust, because Henson Trusts are different. They are still just testamentary trusts. They're still just trusts in a will. Nothing happens, nothing kicks in, typically, until the second death. Upon a first death, it's quite typically the case that everything flows to the surviving spouse by designation, joint ownership, survivorship. So quite often, typically, nothing really passes through the will, passes through the estate upon the first death. But upon the second death, the estate is divided, probate is often required. And let's say that an equal share of the estate is to go into the Henson Trust for this one child. So you need to have absolute and unfettered discretion in the hands of the trustee, such that the beneficiary and anyone else, no one else can force the trustee to disperse funds. Now, of course, this also means you have to be careful in picking your trustee, because the beneficiary is unable to force them to support them. And of course, this is why ODSP is not cut off, because they can't force the trustee to support them. If they could, then they would lose ODSP. But it has to have an absolute and unfettered discretion. And then it has a non-vesting clause, which means that the asset itself, unlike a normal trust, does not beneficially belong to the beneficiary. In a normal trust, beneficially, it belongs to the beneficiary, but it's in the hands of the trustee. In a Henson Trust, it is not, the asset is not vested. It eventually vests in the residual beneficiaries of the trust, which would, if there's more than one child, would typically be the other siblings or their children. And this is all dictated by the parents in the will. Their trust provisions provide for where the residue of the trust goes. And as you'd expect, typically it goes to the surviving siblings or their children. There's also a reversal of an even-handed rule. In a normal trust, the trustee has to somehow keep an even hand between the life beneficiaries and the residual beneficiaries, the remainder men as they're called. And just how you do this is a very good question. But of course, the intention of the parent was that all of the money should be used for the support of that child. Everybody else got their share, or whatever it is, whatever amount that the parent was going to give them, even if it's nothing, but they got theirs. And even if in some cases the total of the estate is left for the one child's trust, which sometimes happens, not common, but it does happen, then it means that all of the money could be used or will be used if needed. But the remainder, if any, but usually there is a remainder, would pass to the residual beneficiaries. But what this means in some cases is, normally, if you had a scenario where the amount of the trust was not great, 100,000, perhaps 200,000, and the benefit recipient on ODSP, the heir, with support, could manage the money themselves, and it's just not worth the ongoing administration and expense of setting up the Henson Trust, which has been proposed and drafted into the will, because you don't know how much the estate will eventually be. If it's correct, if it's the best choice to not set up the trust, then you can do that, or you can set it up and collapse it at any time, like age 65. You could contemplate that. If you have a rebuttal of the even-handed rule, it means that you don't have to keep that even hand, whatever that was going to be. And it also means that you don't have to have the permission or consent of the residual beneficiaries, because the even-handed rule has been reversed. And what this does is, when it's the best choice, the best tactic to not have the trust, which is sometimes the case. This allows us to freely distribute the whole of the amount directly into the hands with support of the heir and bypass the setting up of the trust. There's no limit to the size of that trust, and there's also no limit to what can be dispersed from it. You may hear from time to time that they're limited to 100,000. This isn't true, and that the disbursements are limited to 10,000 over 12 months. That's also not true. This is touching on lifetime benefit trusts. I won't spend a lot of time on this, but if you happen to be one of those families that will have a large RIF, say 200, 300, 400, 500, 600, $1,000 RIF when the second parent dies, then you should consider a lifetime benefit trust to specifically receive that registered fund. Now, the beneficiary of that trust has to have mental infirmities. So it's a question of, well, what is a mental infirmity? Because it's not well described in the Income Tax Act. But we would discuss that and decide. Because what this would do is it will allow you, instead of having the RIF fall into the estate and being taxed, and for simplistic reasons, we use a 50% tax rate. That's probably not true in most cases, but if you happen to, you can pick your timing and die in January, well, then it won't be taxed at 50%. But you can see for explanatory purposes, if you say that you do die in December and you're in a high tax bracket, that the tax would be half, 250 of 500. Whereas if it rolls over to the lifetime benefit trust, it's used to purchase an annuity, just as you could with a RIF, for example. You could annuitize your RIF. And what it does is it pays a certain amount, in this case, 500,000 over 20 with a 20-year guarantee. It's a life guarantee as well, but a minimum 20-year guarantee. And the purpose of that is to make sure that at the worst, all of the capital is paid back, right? And we're not going to have a situation where 3 years later the person dies and the payments end. We have a guarantee period that guarantees all the capital gets paid back to somebody. But you can see here that if you follow through, you'll be able to review this in detail. That over the 20 years, you pay $10,000 in tax. That's basically zero. And if you have a smaller RIF, it is zero. So if you happen to be in a situation where this might fit, we should have a chat. I won't go into detail here. These are just some of the words that you'll hear, the vocabulary around testamentary trusts and Henson trusts. This note here is just to point out that if a Henson trust beneficiary qualifies for the disability tax credit, the trust could purchase a home for him, and each year could make an election to make that a principal residence owned by the trust but occupied by the beneficiary. So it would qualify for the principal residence capital gains exemption when that beneficiary eventually dies and the property is sold. One way that people fund trusts is with life insurance. It can be a very affordable way to do it. So you can see that if you were a female non-smoker, age 50, your life expectancy would be another 35 years. And for this annual premium, you could get a universal life policy of 100,000 or multiples of these numbers, but simplistically 100,000 to fund or add funding to the Henson Trust. So this is a simplistic way for someone who doesn't have assets to at least fund a trust with some amount, or to supplement whatever might go into that trust based upon the estate. And this next slide is interesting because here you're paying this premium, and when you die, it pays 100,000, and we know it's going to pay. That's how it works. You pay the premium, they pay into the trust, and it's designated to the trustee directly. Well, if you take that same amount and you invest it annually, like in a TFSA, because then it's tax-free coming out, just like life insurance. If it's compounded at 4% annually, that's pretty safe, eh? In 35 years, which is the expected lifespan, it's 107,000. So your choice is, if you wish to follow the savings plan, is to invest an equivalent premium and get a 4% return, which is certainly achievable, and to have at the end of 35 years what you would have if you died tomorrow. So it's worth thinking about as an investment. So we're just about on track here. It's 5 after 8. I've been informed by text message to inform you that we're not going to be able to answer all the questions, but I'm quite sure that everybody beavering away in the background, answering as many as they can. Is that what's happening, Karen?
Yeah, I've answered well, Diane and Victoria's helped me. We've answered over 120 questions. We're trying our best. A lot of it's way too complicated to even answer on. So if somebody wants to email our office, we'll be able to help them that way.
It would be
but some of them are way too complex.
It would be best if you didn't just ask the question. It would be best if you gave us some context and filled in the family evaluation form.
Absolutely, because some of these questions, it can go a variety of different ways, and I'm not interested or want to give anybody bad advice.
That's true. Not being a lawyer,
That's right.
That would be imprudent, right?
Even if I was a lawyer, I don't want to give bad advice.
That's a good way to put it too, eh?
Yeah.
Are there any questions? I'm sure there are themes of questions. What have you got a trend here? Have you got a meme, as to what people are interested in?
Lifetime benefit trusts and RDSPs.
Yeah.
Can you touch base on, can a sibling hold an RDSP after the parents pass?
Not unless they're the personal representative or legal guardian.
Okay.
That's the problem. I mean, it's $700,000, and it's interesting if you take a look at the RDSPs. What's happening is you're putting in $1,500, and the government's putting in $4,500, so $6,000. And it's starting at age 18, and you do it for 20 years, and then you stop contributing, and you just keep investing. Well, anybody could do this. It's called a TFSA. So your child turns 18. You contribute $6,000 until they're working and they can contribute $6,000. And you invest it at 5%. And when that child turns 60, he's got the same $700,000 that your other boy has. It's just that his is an RDSP. So it's really just good planning. It's just that people with disabilities have never had this money before. It's never happened. And I'm pleased. Also, a common point is that obviously if you qualify for the disability tax credit, it means that you are markedly restricted, and you may well be not competent. So you may well not be able to do a will because you're not competent. So when you die, what happens is you die intestate, no will, and then by succession law, your siblings receive the RDSP. So even if you think that your child might have a shortened lifespan and may not even survive you, it's possible. If your child dies prematurely, then you, the parent, by succession law, receives the RDSP. There's a bit of rigmarole involved, but that's what happens. And if you have already passed on, then it goes to the siblings, if any. And then eventually, in today's world, if there are no siblings or no children of siblings, then it passes up the ladder to aunts and uncles and then over and down to the cousins who may never have come to visit your son. But then you're gone, and so's your family, so who really cares, right? It's just money.
Another question we had is, can somebody from out of country be the executor of a will in a Henson trust?
Well, you can, and of course in today's world this is a more common issue. But what it means, and this may or may not make much difference, is that the residents of the estate trust and the residents of the Henson trust turns on the residents of the trustee, who is the guiding mind and will. So if you're only potential executor is somebody who's not resident in Canada, well, okay. But the trust will be subject to that jurisdiction's income tax and trust rules. And maybe this is okay. I mean, we have lots of families where it could be that the brother has always been, since university, resident in California. Well, what are you going to do about that? Not much you can do if there's just the two children. So I see we got 31 outstanding questions. That's pretty good.
Another one that's a multiple question, Ken, is what happens if you cash your RDSP out at 60 and you're still on ODSP, or you need to cash it out because your life expectancy? What happens to ODSP then?
Well, all disbursements from an RDSP are exempt for ODSP purposes. There's still income, so there could still be taxation, but the payments we're advised that they are exempt for ODSP purposes, and so far that's what we've seen. They're supposed to also be exempt for guaranteed income supplements. And Karen, would you make a note? We have to talk to Christian to add a slide about OAS and gains at age 65. What happens when you turn 65 is that you start to get old age security of about 7,500. You lose ODSP. You get OAS of 7,500 and about 11,000 of the guaranteed income supplement. But if you have other income, which most people don't, but you might have some small amount of CPP, for example, or you could have income from a trust. And of course, we have ways of dealing with this on the trust side of it. Every other dollar of income after age 65 offsets 50 cents of the guaranteed income supplement. But what we're told, and what seems to be the case, is that the income generated by the RDSP payments does not offset gains. So we're just in early days here. I mean, obviously, RDSPs came in December 2008, so let's say 2009. That's 13 years. So in order to test these things out, you have to have somebody who is 60 and starting to receive funding. Well, that means 13 years ago, they were 50, 46, 47, 13 years ago. So they would only have a very small grant and bond section because you only get it up to age 49. So we don't have a lot of good examples of people turning 60, receiving the money to raise up and say, oh, there, you see, it doesn't affect anything. But we're getting there. But as far as our ODSP is concerned, no. What should happen, what does happen, is you continue to receive your ODSP, plus you get the RDSP payments. The capital contributed by the family is returned as capital. But you can see that if you've contributed 30,000 over 20 years for the 1,500 for 20 years, and you've got 90,000 of grants and bonds, so that's 120, and then you've got approximately $600,000 of growth. Well, the money is returned to you in the exact same proportions. So that'd be 30 to 90 to 600. And each disbursement is in the proportionate amounts of capital, grant bond, and income. And the grant bond and income growth is income. The return of capital is, of course, the return of capital. But the rest of it is income. Now, if a $700,000 RDSP at age 60 involves a payout of about $30,000 a year, a small percentage of that, right, a very small percentage, would be capital. Almost all of it would be income. So let's say 30,000. And by definition, that person presently has a personal tax credit of $14,000 and the disability credit of this side of 9. So for simplistic numbers, $23,000 of tax credits, meaning that 23,000 of 30,000 is not taxed, but 7,000 is taxed at 22%. So about $1,500. So this is still pretty favorable. You're getting 30,000 a year, and you're paying about 1,500 in taxes. Now, it shouldn't affect gains. It could affect other things. We haven't proven that it doesn't affect other things. But still, it's nice to have this problem. So that makes it 7:15 by my watch, 7:16. I think it's
16, yeah.
8:16, thanks. I think it's time to wrap all this up. Can we have everybody back on the screen just to wave goodbye? There we go. That's great. Nice to see all these smiling faces. I think Kevin's probably fallen asleep, but that's okay. He needs his beauty sleep. So I'd like to say— He
gets up early.
That's true. He gets up before, he's in here before we are. So I'd like to say thank you to everyone. I hope this has been useful.
Thank you.
We try to keep it short. And oh, there you will. I see you look better already. So we try to keep it useful and short and simple language. There's a great deal of other additional material on the website, lots of 3-minute videos. And we try to keep the wording simple. If you go to a lot of legal websites, you're going to see a lot of legal verbiage. And I think, I'm a lawyer, so perhaps I know a little bit about it. I think that it's, at a subconscious level, it's an attempt to show how smart you are. Because lawyers are smart, we are smart. We don't know everything. I certainly don't. But, putting things down in legalese isn't the best thing for clients. Putting it down in the words that they understand rather than a vocabulary they don't understand is probably a better procedure. So that's what we endeavor to do. So, try gaining information from the website, fill out the form, and if you'd like to speak to us, contact Kevin and he'll set things up.